This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court has unanimously revived the lawsuit by an Atlanta family whose home was mistakenly raided by the FBI in 2017. Armed members of an FBI SWAT team smashed in a front door, set off a flashbang grenade, and held the family at gunpoint until they realized they had raided the wrong home. Lower courts had dismissed the lawsuit brought by the family under an exception to the Federal Tort Claims Act that shields the government from liability when it comes to giving federal officers discretion to carry out their jobs. But in the majority opinion, Justice Neil Gorsuch said the lower courts might be applying the exception too broadly, noting that the FBI agent in charge had missed the street sign and the house number, something he noted during the oral arguments.
Here, petitioners suggest, for example, that the officer should have checked the house number.
Yeah, you might look
mailbox.
At the address of the house before you knock down the door.
Yes, and as the district court found at 52A, that sort of decision is filled with policy trade-offs because checking the house number at the end of the driveway means exposing the agents to potential lines of fire.
How about making
windows?
sure you're on the right street? Is that?
And how does that?
Just the right street.
I was just going to
checking the street sign. Is that asking too much?
The court sent the case back to the 11th Circuit for more findings. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. Hal, tell us about this lawsuit.
The lawsuit arose because FBI agents, in trying to serve a warrant, went to the wrong house. It was the wrong street. It was the wrong address. And so they were just evidently plainly negligent, and they crashed through the door, creating damage to the house and scared the wits out of the recipients when they saw these people coming in and they were trying to hide from armed intruders. So the FBI was looking for drug dealers, and evidently they took a little while to find out that their mistake. And so afterwards, the private citizens sued under the Federal Tort Claims Act, which is a waiver of sovereign immunity from the United States to allow tort suits in particular contexts and compensation both for the physical injuries as well as for the injuries to the house. And this took place outside of Atlanta, which is in the 11th Circuit. And the 11th Circuit.
So explain a little bit more about the Federal Tort Claims Act and the exception that shields government from liability to give officers discretion.
So prior to 1946, the Supreme Court had never waived the federal government's immunity from tort suit. So if one was injured by a federal agent or by a post truck driver, one had to submit a private bill to Congress in the hope of compensation. And Congress sort of modernized the system by creating this mechanism to allow federal agencies to be sued in tort, but with some exceptions. And the law of the case is to take place in the states. Individuals have to make a claim to the agency before they can go to court. But the most important exceptions, two exceptions in this case, are first, there is an exception for intentional torts, but carved out of the intentional torts are law enforcement personnel. So the idea of a carve-out for intentional torts is evidently that it's just if a federal official is acting intentionally to hurt someone, they're not arguably within the scope of their employment. And so Congress decided that they should be sued in their own individual capacity. But at the same time, Congress decided that if it was a law enforcement agency, then there needs to be extra protection, and so that the federal government would be substituted instead of the law enforcement agents if anyone suffered an intentional tort at the hand of the law enforcement agencies. So that's the general structure first of the law enforcement proviso, which limits the intentional tort exclusion under the Federal Tort Claims Act. So according to the Supreme Court, the 11th Circuit got it wrong two ways. First, the 11th Circuit held that, and this is pro-plaintiff, if there is law enforcement personnel involved, as in this case, not only does the intentional tort exception not apply, but also that the second major exception in the Federal Tort Claims Act, the discretionary function exception, doesn't apply as well. And the discretionary function exception is that, yes, the government has waived its immunity for negligence suits, but if there's some kind of policy, social, economic, political policy underlying that negligence, the government has not made a waiver because it doesn't want courts to second-guess government action when it's grounded in social, economic, and political policy. So back to the 11th Circuit says that the waiver for law enforcement officials applies to discretionary acts as well. All right, so far that's been a very pro-plaintiff decision, but then the 11th Circuit grafts on another defense for the government that's not in the statute. They call it the Supremacy Clause defense. And under Supremacy Clause defense, the government can come in and say, law enforcement officers were basically doing something at our will, and it can't be second-guessed in state court. This is not in the Federal Tort Claims Act, and that was the basis on the lower court ruling in favor of the federal law enforcement officers in this case. So the Supreme Court took it and said, you've misread the statute twice, and yes, under the congressional statute, you can sue law enforcement agencies for intentional torts and also for negligence. But the discretionary function exception will apply, and they remanded the case back to the 11th Circuit for a proper application of the statute. It's a unanimous case. It should be. The 11th Circuit just read the statute wrong for reasons that are unknown to me, probably unknown to the court as well. And I think it's pretty clear that the kind of negligence that's at stake in going to the wrong house, the wrong address, to break into the house to try to apprehend the gang, that's operational negligence. It's not based upon any kind of social, political, economic value judgment, and it's pretty clear that the government's going to lose on remand.
Even though the district court said that the lead FBI agent had taken significant precautions in preparing for the raid and had simply made a mistake.
That's negligence, and those mistakes are not covered by the discretionary function exception. And indeed, Justice Sotomayor wrote a concurrence just to spell that out. And in her view, messing up the address on a warrant is like making a mistake at a stop sign. Those are operational negligence, and Congress said that the government should pay out when its agents make those kinds of mistakes.
Justice Gorsuch wrote, if federal officers raid the wrong house, causing property damage and assaulting innocent occupants, may the homeowners sue the government for damages? The answer is not as obvious as it might be.
First, the entire structure of the Federal Tort Claims Act is unusual in that Congress adopted the law in the jurisdiction where the injury arose. So the federal government, in essence, is being governed by 50 different state laws as to, in this case, assault or adequate preparation. So that's why it's never easy to predict. But, I think that in this case, at least from the facts that we were privy to in the Supreme Court decision, going to the wrong house is hardly ever a policy issue. It's basically one that's just based upon the GPS mistake, not seeing the car in the driveway, it was a different car, and not seeing the address on the address sign.
So this is going back to the 11th Circuit. What are the questions that the 11th Circuit has to answer?
The 11th Circuit will ask whether the negligence in this case stems from political, social, and economic policy, or is rather considered operational negligence. And again, from the facts that we learned in the Supreme Court decision, there was no kind of judgment call. Here's a necessity. We have to take a risk because we see somebody fleeing, so we have to go into this house. There was nothing like that, which might be more policy-centered, but rather they went to the wrong street and the wrong address. That's pretty inexcusable.
So let's say the 11th Circuit rules as you say. So, does it go to trial then? What happens next?
It will go to trial. There will be no jury trial. That has been exempted out of the Federal Tort Claims Act, but there will have to be a trial as to the proper amount of damages, and that, of course, could be subject to appeal as well, and that's paid out of the judgment fund.
Was it surprising that this was unanimous?
I think this is the right way to read the statute. I think it's pretty clear from both prior cases in other circuits as well as from the legislative history that the 11th Circuit got it wrong. And I think this is just one of these instances where the court took the case to clean it up. But interestingly, this is now going to give Senator Padilla, who was treated so rudely at Kristi Noem's press conference, he now would be able to sue under this very theory. I think his is a little more difficult factually, but he now would have an avenue to sue.
You mentioned Senator Padilla. Does this ruling strengthen future efforts to seek compensation for federal law enforcement misconduct?
It does. I mean, I think that it's righting a wrong because the 11th Circuit had it too crabbed of a decision. But in this case, theoretically, Senator Padilla could argue that there was law enforcement officers that acted negligently in trying to tackle him and subdue him, way and beyond an exercise of force that needed to be applied. I think it's going to be a harder case, but he certainly has that avenue open.
Is there a possibility this might end up at the Supreme Court again?
I doubt it. I think that in this case, the court took the case just to sort of correct the case law and to make sure that the principles that the 11th Circuit applies in the future adhere more closely to the statute. I don't think there's anything inherently controversial, though I do agree with Justice Sotomayor when she said that the Supreme Court has not taken a case in 25 years in this area, and so there is a lot of disagreement about how to frame the proper inquiry, and so that some other case might be appropriate for the court to take in order to give more direction to lower courts.
The federal agents themselves wouldn't have to pay the damages.
No, once you sue the United States, then the employees are exempted out of the claim and will be immune. Theoretically, the federal government could do a third-party suit against the employees for some kind of contribution, but they never do that, or almost never. And so, in essence, again, the judgment would come from the judgment fund.
Okay, Hal, stay with me. Coming up next on the Bloomberg Law Show, we'll look at some of the high-profile cases the justices have yet to rule on, with about 2 weeks left in the term. I'm June Grasso, and you're listening to Bloomberg. The Supreme Court is just two-thirds through the cases on its docket, with about 2 weeks left in the term. The justices have yet to rule on 21 cases, including some involving hot-button issues like gender-affirming treatments for minors, a clash over LGBTQ school books, and one of President Trump's most audacious immigration initiatives. I've been talking to Professor Harold Krent of the Chicago-Kent College of Law. One of the cases that stands out is the one over Tennessee's ban on gender-affirming care for minors. And that was argued the first week of December, and it seemed pretty clear that there were 5 justices, conservatives, who were skeptical of the contentions that the Tennessee law violated the Constitution. Why is it taking so long?
Well, the other issue in that case is that the administration is flip-flopped. And with the Trump administration disavowing the position that the Biden administration took, which was that, of course, that the law was unconstitutional. So we all speculated at the time that the court might even get rid of the case because of that change of position. It probably won't do that, but I don't know what's taken the court so long. So it is somewhat mysterious, but we expect some kind of decision imminently.
This is going to be one of the more controversial cases of the term. And they seem to leave those to the end of June, although you'll hear the explanation for that is that the cases are controversial, so there may be more concurring opinions or dissenting opinions. But it also seems to me like they hold them till the end.
Yeah, and of course the same is true for the birthright citizenship case, which is probably the other very controversial case, both because of the merits of the birthright citizenship issue, but also because of the question of the nationwide injunction. So I would expect to see that on the last day. So it is a typical Supreme Court tack. And I guess the other one I would put in that same category is the question of whether parents have an opt-out, can take their kids and pull them out of class if the class is teaching something that strikes against their religious beliefs. I mean, that decision will create incredible havoc for public schools who are trying to then have to give notice of every book that may be read, which is particularly difficult for show and tell if the kids bring in stories, and then have some kind of monitoring of the kids while those texts are being discussed in class. So from the argument, again, it sounded like the court was going to allow an opt-out based on religion, but that implementation of that would be incredibly difficult. So I think that's going to be one of the more controversial decisions of the term as well.
You know, the Supreme Court has dealt with several gay rights and trans rights cases, and they've decided to take for next term a case over Colorado's ban on conversion therapy. So they're not shying away from issues in this area.
Well, and of course, what really is underlying these decisions are whether the permission for gay marriage will remain intact, or will the court, because of its religious views, decide that the right of gay marriage, so to speak, should be revalued.
I know that there are conservative justices who are looking to do that, and there is a movement to reverse the Obergefell decision. But wouldn't that be difficult to do? Because then what happens to all the gay couples who got married and, relied on that decision? What are they going to say? Your marriage is not valid now?
No, that would make it prospective if they did that. And, of course, it's also complicated because the post-hoc decision, which recognized you could have a civil rights action if you demote someone or treat them differently because they're gay. But nonetheless, there is this movement that's trying to get the court's attention to try to use another case to reverse a not-so-long-standing, 10-year standing precedent. But it's not coming now, so that's something we don't have to worry about imminently.
Are there any other cases that you're waiting to hear the decision on?
Well, there's the case involving whether you can limit pornography websites to some kind of age verification. And that's not so important, I think, because of the question, because, of course, you can have age limitations in movies and on porn sites. It's the question is, what's the standard of review? And in that case, the conflict was any kind of restriction on First Amendment, you have to use strict scrutiny, or as in that case, then you use rational basis, and if it's rational basis, it's just an easy test. So it's not important, again, for the facts of the case, but articulating the standard review in First Amendment cases does remain incredibly critical for a host of contemporary reasons, as you're well aware.
Yeah.
And I can just add that there's two decisions that are pending involving either excessive delegations from Congress to private parties or rechristening the private parties as inferior officers and upholding the delegations. So the court probably won't give a bombshell in either of those cases, but they may give out some clues as to the future of the non-delegation doctrine and their willingness to permit private parties to play some role in shaping the governance of a country.
And just explain the non-delegation doctrine.
Yeah, so non-delegation doctrine says that Congress must be very specific in giving authority to agencies, that the agencies can have the power to fill in the details, but they can't have the power to make policy themselves. And no court has been able to figure out where the line is between the two. And so it's a continuing issue, particularly on this court, to try to articulate more limits on how much power Congress can do and how specific Congress must be in giving power to the agencies. And that might be true even more so to the extent that there's private parties involved in these cases. And there's one case in which the private party is definitely involved, the other one that's more hazy in terms of the legislative structure of the delegation. But the court may, for instance, say that private parties can only do ministerial tasks, and anything more would be a violation of the non-delegation doctrine. And in the one case, there was imposition of a fee on broadcasters in order to ensure adequate access to service in broadband and telephones in schools and rural areas. And that role of the private parties, is like a tax. And so the court may say that is stepping too far, that Congress can't allow any kind of private party to help with imposing a tax. So there are some variations of the decisions which could create a doctrine which even more limits the power of Congress to enroll agencies and or private parties in trying to implement national priorities.
There's been so much emphasis on the shadow docket or the emergency docket since Trump became president and has filed so many emergency appeals with the court. So a lot of the most controversial issues are being decided on the shadow docket, perhaps making the regular docket a little more subdued this term. Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. U.S. Health Secretary Robert F. Kennedy Jr. is a known vaccine skeptic For example, 2 years ago, he suggested that the polio vaccine has killed more people than polio did, and he's linked the measles, mumps, and rubella vaccine to autism, a theory that's been widely debunked. Kennedy has repeatedly said he won't do anything to keep people from getting vaccines.
I'm not going to take away anybody's vaccine. If people are happy with their vaccines, they ought to be able to get them. What we're going to do is give people good science.
But some of Kennedy's recent moves, including dismissing all the members of a key panel that advises on immunization policy, seem to be steps toward implementing his blueprint to cast doubt on the effectiveness and safety of a broad range of vaccines. My guest is Nyah Phengsitthy, Bloomberg Law healthcare reporter. RFK Jr. wrote on X, "I took a major step toward restoring public trust in vaccines by reconstituting the Advisory Committee for Immunization Practices." Tell us what he did.
Yeah, so Kennedy last week fired all 17 members of the Advisory Committee on Immunization Practices, also known as ACIP. And this is a panel of public health and medical experts that advise the CDC on vaccines and what shots should be recommended in the U.S. So this is a very important panel because they vote on what vaccines should go on the CDC's recommended immunization schedule. Now, that schedule or that list is very important because doctors use that to determine which vaccines to give to patients. And it's also important for insurers because they use that to determine what vaccines to cover. Now, before Secretary Robert F. Kennedy Jr. dismissed the last ACIP committee, there were 17 members, and he pointed out in his press release after posting on X that the Biden administration appointed all 17 of those sitting ACIP members. 13 of them were appointed in 2024. Now, what Kennedy did here, he said he retired all of them, dismissed them, and that raised alarm for various public health experts and even drug industry because there were concerns that Kennedy would replace his members with anti-vaxxers, especially with Kennedy's vaccine skepticism. And there were concerns that he would replace those people with folks who have spread misinformation about the safety and efficacy of vaccines, even shots that have been approved by the FDA to be safe and effective.
And what about the people he's now appointed to the committee?
So he has already appointed 8 new members last week, which, by the way, is the minimum number of members for ACIP needed. And when he selected 8 new members, that included people that actually have anti-vax views and are against mRNA vaccines and the COVID-19 vaccine or have found those vaccines to have safety issues. One of them is Robert Malone. He is a major opponent of mRNA vaccines. He also selected Retzev Levy, who's a professor at the Massachusetts Institute of Technology, who's questioned the safety of COVID vaccines. He also picked Martin Kulldorff, a former Harvard Medical School professor who was the co-author of the Great Barrington Declaration, and that was a manifesto that came out during the pandemic that called for alternative COVID lockdowns during the pandemic. And it's also already been reported that Malone and Kulldorff were paid expert witnesses in Merck vaccine cases. So there's already concerns because after Kennedy dismissed the ACIP members, he went back on X and posted writing that he wouldn't put anti-vaxxers on the panel, but rather, quote, put highly credentialed physicians, end quote. And so we've seen folks with anti-vax views now on that panel. So there's already concerns about who's been put on there.
Despite the fact that he made promises during his confirmation hearings that he would not attack vaccines, what else has he done to stall or cast doubt on vaccines so far?
Even before this significant decision to dismiss and restock ACIP, Kennedy was already making moves at vaccines. So back in May, he announced through a video on X that he would be removing the COVID-19 vaccine from the CDC's recommended immunization list for healthy children and healthy pregnant women. And that move raised the alarm for industry again because Kennedy didn't really share any details on how he came about that decision. And the attorneys I've spoken with say that, there were procedural issues on how he went about that. Earlier this year, he also said that he will be requiring all new vaccines to undergo placebo-controlled studies before they're approved. Now, that would be a major policy shift because that means vaccines will have to go through safety trials where some participants will receive a placebo injection before the shot can be licensed. The concern there is that if the disease already has a vaccine, the study is unethical because a participant in the trial would be exposed to a preventable illness. We also know that vaccines for emerging diseases already undergo placebo-controlled testing during development. So he's already made numerous moves that show his agenda to scrutinize vaccines, and we are expecting more, and he appears to be moving at a pretty quick pace.
Is there a chance that he could look back at vaccines that have already been approved?
I can see that. I mean, Kennedy has repeatedly questioned vaccine safety testing for quite some time now. His skepticism really gained wider popularity during the COVID-19 pandemic, especially with skepticism against mRNA vaccines. He said during his campaign trail that he wouldn't be taking vaccines away, but I think, folks are just also skeptical of how he's going to move. He's questioned the safety of many other vaccines, including, linking the measles, mumps, and rubella, or the MMR vaccine to autism, which is a theory that's been widely debunked. But we know that he's going to keep looking into vaccines, even past ones, because in his Make America Healthy Again report that came out in May, there was a section on vaccines, and that highlighted how he's going to look into them, areas that warrant future inquiry. There was a part that says that he's going to look into conflicts of interest in the vaccine recommendations tied to the pharmaceutical industry, and we already see him doing that with the ACIP committee. But based on that report, his next steps are likely to address changes to clinical trials, more investigations into vaccine safety and the science that really underpins the approvals. And then the report also calls on the expansion for the department's autism data initiative to better study childhood chronic diseases. So we know that Kennedy is supposed to come out with a report in, I believe, September on what causes autism. And, we're eager to know what's going to be in that report. And we're wondering if there will be something in there that links, vaccines to autism, which, again, has been debunked. But we are curious to know what will be in there.
How consequential is it that he yanked a $766 million contract with Moderna to develop mRNA vaccines for avian influenza?
It's a big deal because, one, that is a lot of money to do research into mRNA and to prevent future diseases and flu and pandemics. So the concern there was when he yanked that, folks were like, does he not want Moderna to study mRNA and to look into that? So it kind of poses some threat to mRNA vaccines. Is he slowly chipping away at it? Because, again, he's always had the skepticism with it, and then to yank that contract with Moderna was a very big deal.
And explain what an mRNA vaccine is.
mRNA is created in the lab to teach our cells how to make a protein, and that protein triggers an immune response in our bodies, and that immune response produces antibodies, which help protect us from getting sick from that germ in the future. So in this case, with the COVID-19 vaccine, that mRNA vaccine helps us from getting sick from COVID in the future. And it was mRNA during the first Trump administration was just a major breakthrough because it's something the Trump administration harnessed when they were making vaccines to battle the COVID-19 pandemic. And it was major for COVID-19, but it is also big for treating other diseases. So it's not just about COVID. So mRNA can do a lot. I've talked to scientists who are like, it's the next big thing. So to be chipping away at it, if we do, is a big concern.
Do the people that you've talked to in this area think that he'll just chip away at the public confidence in vaccines? He'll stop new ones from coming out, or that he's going to go after the vaccines that are already out there?
I think it's both. I think for the vaccines that are already out there, he might find a way to go back and look at the, safety data to see if there's something there to look into. And then for future vaccines that haven't hit the market, there might be, obstacles that are there for those manufacturers to get them across the finish line to get approved. Because, again, we're dealing with a secretary who is not only skeptical of vaccines, but also is skeptical of the pharmaceutical industry. We've seen Kennedy make comments about his, issues and concerns and questions around pharmaceutical industry profits and conflicts of interest and how there's relationships between federal agencies and manufacturers. So industry is also dealing with that. It puts them kind of in a weird spot right now in how to move forward with manufacturing these vaccines. But yes, I've talked to people who are like, he will chip away at these vaccines. I talked to one source who's like, this is like the frog in a boiling pot situation where he's going to go at vaccines with small measures, and he's going to do it slowly, but at the same time, we see him moving quickly right now.
During his confirmation hearings, a lot of the senators were concerned about his views on vaccines. So Kennedy's recent moves have caused health professionals to be concerned. What about lawmakers?
A good number of lawmakers have expressed concerns with this. I think the most important reaction we got was from Senator Bill Cassidy after Kennedy made this decision, because during Kennedy's confirmation hearing, before Cassidy decided to vote for Kennedy to become secretary, he said that Kennedy would, quote, maintain the committee. And that could have meant many things, and that clearly has not been the case because the committee is now dismissed. And Cassidy posted on X that he spoke with Kennedy. You know, we haven't really heard any details since then, but I know that this is a concern for Cassidy because that was one of the promises that Kennedy made to the senator, which, you know, got him that vote from Cassidy.
I think we've seen time and time again, not only with government officials, but also with Supreme Court justices, that promises made or assurances given during confirmation hearings are not always kept. Thanks so much for joining me, Nyah. That's Bloomberg healthcare reporter Nyah Phengsitthy. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.